Okay, that needs to be turned off.
All right, good afternoon, everyone. Welcome to the GRC December 10th council meeting, December 10th, 2020. Executive Director Russo. Process of
Frank, your volume is a little low.
Frank, you're cutting out.
I can't hear you, Frank.
now. We good?
No.
No, still very low.
How about now?
A little better.
Teams has been playing this game with me now for a little bit. I'm not happy about it, so I'm gonna have.
Now it's good. Now it's good.
Yep.
Okay. It may not stay that way. So Sam, if you could just hit me in the chat if it starts to go in and out again. This has been going on for 2 weeks. I don't know why it's happening. All right. Chairman Alexi, if you'd like to take it away, we can start the meeting.
Thank you, Director Caruso. Good afternoon, everyone, and welcome to the December 10, 2024 GRC meeting, our last meeting of calendar 24. Can we turn that off?
Yeah, I'll figure out how to do it.
Okay. Everyone, please rise for the pledge. Pledge allegiance to the flag of the United States of America,
and
to the republic for which it stands,
one
one
nation,
nation, under God,
indivisible,
with liberty and justice for all. This meeting was called pursuant to the provisions of the Open Public Meeting Act. Notices of this meeting, inclusive of call-in information, were faxed to the New York Star Ledger, Trenton Times, Courier Post Cherry Hill, the Secretary of State on December 5, 2024. Members of the public attending the meeting via telephone have been placed on mute by the presenter. At the time the council arrives at its public comment portion of the meeting, members will be taken off mute and given an opportunity to provide public comment. Please note that the council will strictly adhere to the 5-minute time limit. Additionally, copies of today's meeting agenda can be accessed on the GRC's website at https://www.state.nj.us/GRC/meetings/minutes/. Proper notice having been given, the secretary is directed to include this statement in the minutes of this meeting. Roll call, please.
John Alexi.
Present.
Robin Bertabakin.
present,
Christopher Brown.
Present.
Ronald Chen.
Present.
Stephen Retardi.
Present.
Mr. Caruso, would you like to kick us off with the executive director report?
I sure would. Hopefully everyone can hear me.
We can.
Good. All right. Well, we get to begin today's director's report by welcoming our 2 new staff attorneys, Mia Rossi and Jennifer Howe. Both are joining the GRC from private practice and have had a great first week of training. We're very happy to have them and look forward to integrating both of them into the adjudication process here shortly. So happy to have some help. And looking forward to much success. So that's some good news. Good news for us for this month. As always, we'll go into our current statistics. Since our inception in July 2002, the GRC has received 7,210 denial of access complaints. It's averaging about 320 annual complaints per 22.5 track program years. As a note to our public members, program years are measured in fiscal years, which are July 1st to June 30th. Right now we are in fiscal year 2025. That's our current program year. We've received 96 denial of access complaints. As for a breakdown of the status of all of our pending complaints, we have 550 open complaints out of the 7,210. It's about 7.6% of all complaints filed. A breakdown of where they're at. We have 8 complaints currently on appeal, 20 complaints in mediation, 1 complaint proposed for the Office of Administrative Law, 27 complaints awaiting adjudication at the Office of Administrative Law, 31 complaints tentatively scheduled for an upcoming meeting, which includes today's meeting, and 463 complaints, which are considered work in progress that we're still working on. Since program year 2004, again, fiscal year 2004, the GRC has received and responded to 40,070 total inquiries. So we're over the 40,000 number for the agency history. So we average about 1,864 annual inquiries per 21 and a half track program years. As always, noting that we did not track inquiries in our first year. So far in the current program year, again, fiscal year 2025, the GRC has received 816 inquiries, which is equal to about 7.4 inquiries per workday. Finally, for our GRC outreaches, as I announced at last month's meeting, our annual seminar, our 16th annual seminar, is happening in 2 days on December 12th, 2024. It is virtual, and the registration information is on our website, on our homepage. Again, we'll be offering CLE and CEU credits to attendees, and we'll attempt to record the sessions this year in hopes of producing a watchable product. Unfortunately, in the past couple of years of doing it virtually, we've had some technological issues that didn't necessarily translate into pretty good recording. So we're hoping to get a good recording that we'll be able to post through our website after Thursday's seminar event. So that is my report for December of 2024.
Well, thank you, Mr. Caruso. Our next item is the approval of the 2025 proposed council meeting dates. Mr. Caruso, would you read the proposed dates for those in attendance?
I will indeed. Let me pull them up real quick. Thought they were in my packet, but I think I moved them around. All right. So our proposed dates for 2025. It's ready. Yeah. All right. So January 28th, 2025, February 18th, 2025, March 25th, April 22nd, May 20th, which is moved up from Memorial Day week, June 24th, July 29th, August 26th, September 30th. Our combined October-November meeting will be on November 6th, and our December meeting will be on December 9th. So those dates were all provided to the members of the council. Hopefully they are satisfactory to the council.
Is there any discussion on the meeting dates? Hearing none, can I have a motion?
So moved that we adopt them.
I think you're muted, Stephen.
I was indeed. Second. Sorry about that, Mr. Chairman.
Not a problem.
John Alexi,
Yes.
Robin Bertabaki,
Yes.
Christopher Brown,
Yes.
Ronald Chan,
Yes.
Stephen Retired.
Yes.
So there's no closed session. Next is approval of the minutes of the previous meeting. Is there any discussion regarding the approval of the November 7th, 2024 open session meeting minutes? Hearing none, can I have a motion to approve?
I move they be adopted.
Second.
John Alexi,
Yes.
Robin Bertabaki,
Yes.
Christopher Brown,
Yes.
Ronald Chan,
Yes.
Stephen Retired.
Yes.
Okay. We move on to new business. Cases scheduled for consent agenda administrative complaint disposition adjudication. An administrative complaint disposition means a decision by the council as to whether to accept or reject the executive director's recommendation of dismissal based on jurisdictional, procedural, or other defects of the complaint. The executive director's recommended reason for the administrative disposition is under each complaint below. First
Chairman
is
Alexi, before we move on, DG Branson, did you accidentally raise your hand or?
That appears to have been an accident. I apologize.
Okay. I want to make sure we're not missing something important here.
Just
Thank
my
you.
error. Sorry about that, guys.
Thank you, Mr. Caruso, since I missed that. First is administrative disposition adjudications with recusals, consent agenda. We have two, which I will read. However, these cannot be adjudicated due to lack of quorum. David Weiner v. County of Essex, 2023-96. David Weiner v. County of Essex, 2024-218. And again, they cannot be adjudicated due to lack of quorum. Next is administrative disposition adjudications with no recusals, consent agenda. We have 6, which I'll read and we'll vote at the end. Ritomo Owa Esquire, on behalf of African America Data and Research Institute v. Colts Neck Police Department, Monmouth, 2022-105. All records provided in a timely manner. Victor Malyar v. Monmouth County Board of Taxation, 2022-651. No records responsive to the request exist. Scott Medlinger v. Berkeley Township Police Department, Ocean, 2023-114. All records responsive, provided in a timely manner. Darlene Esposito v. Mercer County Prosecutor's Office, 2024-188. No responsive records to the request exist. David Wyke v. New Jersey Department of Law and Public Safety, Division on Civil Rights, 2024-216. Motion to file within time denied. Trip Kendall v. New Jersey Department of Children and Families, 2024-217. Not a valid OPA request. Is there any discussion? Hearing none, can I have a motion?
Move that the recommendations be accepted.
Second.
John Alexin,
Yes.
Robin Brett-Tabakin,
Yes.
Christopher Brown,
Yes.
Ronald Chan,
Yes.
Terry Todd,
Yes.
Next is administrative disposition, uncontested, voluntary withdrawals by complainant. No adjudication of the council is required. However, there are 12, which I will read. Scott Medlinger v. Lacey Township Police Department, Ocean, 2022-513. Complaint voluntarily withdrawn. Tamara Rudo Steinberg v. Cherry Hill Public Schools, Camden, 2024-36. Complaint settled in mediation. Tamara Rudo Steinberg v. Cherry Hill Public Schools, Camden, 2024-37. Complaint settled in mediation. W. Rob Graham v. Lawnside School District Board of Education, Camden, 2024-115. Complaint voluntarily withdrawn. Jenna Bloom v. New Jersey State Police, 2024-118. Complaint settled in mediation. Robert C. Scutro v. New Jersey Department of Community Affairs, Division of Codes and Standards, 2024-148. Complaint settled in mediation. Nelson Dice v. City of Ocean City, Ocean, 2024-150. Complaint settled in mediation. Michael Jones v. New Jersey State Police, 2024-151. Complaint settled in mediation. David J. Durling v. New Jersey Department of Corrections, 2024-160. Complaint voluntarily withdrawn. Sarah Heimowitz, Esquire, on behalf of Arlene Johnson v. New Jersey Department of Labor and Workforce Development, Board of Review, 2024-228. Complaint voluntarily withdrawn. John Path v. City of Jersey City, Hudson, 2024-239. Complaint voluntarily withdrawn. Kevin Kearns v. Borough of Shrewsbury, Monmouth, 2024-243. Complaint voluntarily withdrawn. We're on to new business. Cases scheduled for consent agenda. Administrative order. An administrative order means an order issued by the council requiring records custodian or the complainant to perform a specific action in furtherance of the adjudication of a pending denial of access complaint or taking other actions deemed appropriate to adjudicate a complaint in an expedited manner. The executive director's recommended reason for the administrative order is under each complaint below. Administrative orders with recusals consent agenda, we have none. Administrative orders with no recusals consent agenda, we have none. New business cases scheduled for individual complaint adjudication. The executive director's recommended action is under each complaint below. Individual complaint adjudications with recusals. We have 4, which I will read. However, again, these cannot be adjudicated to lack of quorum today. Peralt Jean Paul v. City of Jersey City Hudson, 2022-317. Marie Diamante v. Rutgers University, 2022-355. Marie Diamante v. Rutgers University, 2022-388. And Maria Diamante v. Rutgers University, 2022-398. Again, these cannot be adjudicated to lack of quorum. Next is individual complaint adjudications with no recusals. Rotimi O. Esquire on behalf of American Data and Research Institute v. Burlington Township Police Department, Burlington, 2022-64.
The custodian performed an insufficient search to locate records responsive to the portion of the request seeking agreements, NJSA 47:1A-6, Winerby County of Essex, GRC complaint number 2013-52, September of 2013, citing Schneebel v. New Jersey Department of Environmental Protection, GRC complaint number 2007-220, April 2008. However, the GRC declines to order disclosure because the custodian did so on April 19, 2022. The custodian did not unlawfully deny access to the portion of the complainant's OPA request seeking disclosable personnel information because all records were disclosed. Janice v. Garfield Board of Education, Bergen. GRC complaint numbers 2009-156 EDSEC, interim order dated April 28, 2010. And Owo Esquire, OBO Adari v. Voorhees Township Police Department, Camden, GRC complaint number 2022-12, March of 2024. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Is there any discussion? Hearing none, can I have a motion?
Move to adopt.
Second?
John Alexi,
Yes.
Robin Briggs Abakin,
yes,
Christopher Brown,
Yes.
Ronald Chan,
Yes.
Stephen Retard,
Yes.
Rotimi O. Esquire on behalf of African American Data and Research Institute v. Manasquan Police Department, Monmouth, 2022-76.
The custodian's response was insufficient because she failed to address each OPA request item individually, NJSA 47:1A-5G, and PATH v. Willingboro Board of Education, Burlington, GRC complaint number 2007-272, May of 2008. The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified, and the record reflects, that no records exist. Hooser v. New Jersey Department of Education, GRC complaint number 2005-49, July of 2005. The custodian unlawfully denied access to the portion of the complainant's OPA request seeking personnel information because the disclosed spreadsheet was derived from individual physical records. Valdez v. Union City Board of Education, Hudson, GRC complaint number 2007-156, February of 2008. Custodian shall thus disclose, locate and provide such records. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with C 5:105-2.13.
Is there any discussion? Hearing none, can I have a motion?
Move to adopt.
Second?
John Alexi,
Yes.
Robin Briggs Abakin,
yes,
Christopher Brown,
Yes.
Ronald Chan,
Yes.
Stephen Retard,
Yes.
Rotimi Owa Esquire on behalf of African American Data and Research Institute v. East Brunswick Police Department, Middlesex, 2022-106.
The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified, and the record reflects, that no records exist. Hooser GRC 2005-49. The custodian unlawfully denied access to the portion of the complainant's OPA request seeking personnel information because the disclosed spreadsheet was derived from individual physical records. Valdez GRC 2007-156, The custodian shall thus locate and provide such records. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Is there any discussion? Hearing none, can I have a motion?
Move adoption.
Second.
John Alexi,
Yes.
Reverend Victor Vacchi,
yes,
Christopher Brown,
Yes.
Ronald Chin,
Yes.
Stephen Retard,
Yes.
Rotimi Owa Esquire, on behalf of African American Data and Research Institute v. Chester Township Police Department, Morris, 2022-109.
The custodian unlawfully denied access to the portion of the complainant's OPA request seeking personnel information because the disclosed spreadsheet was derived from individual physical records, Valdez, GRC 2007-156. The custodian shall thus locate and provide such records. The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified, and the record reflects that no records exist. Hoosterhopper, GRC 2005-49. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Is there any discussion? Hearing none, can I have a motion?
Move adoption.
Second.
John Alexi,
Yes.
Reverend Victor Vacchi,
yes,
Christopher Brown,
Yes.
Ronald Chin,
Yes.
Stephen Retard,
Yes.
Rotimi Owa Esquire, on behalf of African American Data and Research Institute v. Mansfield Township Police Department, Burlington, 2022-119.
The custodian's response was insufficient because she failed to address each OPA request item individually. 47:1A-5G and PATH GRC 2007-272. The custodian did not unlawfully deny access to the portion of the complainant's OPA request seeking disclosable personnel information because all records were disclosed. Danish GRC 2009-156 EdSec and Voorhees GRC 2022-12. The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified, and the record reflects that no records exist. Hoosterhopper, GRC 2005-49. The complainant is not a prevailing party.
Is there any discussion? Hearing none, can I have a motion?
I move adoption.
Second.
John Alexi,
Yes.
Reverend Victor Vacchi,
yes,
Christopher Brown,
Yes.
Ronald Chin,
Yes.
Stephen Retard,
Yes.
Scott Madlinger v. Borough of Seaside Heights, Ocean, 2022-535.
Mr. Chairman, there is a brief amendment to this FR. It is after the additional submissions subparagraph on page 3, and it's in the form of a footnote. The footnote reads as follows. The complainant did not directly state a claim of a deemed denial. However, the GRC would have rejected such a claim had it been raised based on the custodian's certification, which is uncontradicted.
Thank you, Mr. Stewart.
All right. For the sake of reading the conclusion, the custodian lawfully denied access to an email log because she certified, and the record reflects that no records exist and could not be produced. Hoosterhopper, GRC 2005-49.
Is there any discussion? Can I have a motion as amended?
I move adoption as amended.
Second.
John Alexi,
Yes.
Reverend Victor Vacchi,
yes,
Christopher Brown,
Yes.
Ronald Chin,
Yes.
Stephen Retard,
Yes.
Scott Madlinger v. Lacey Township Police Department, Ocean, 2022-635.
The custodian lawfully denied access to the requested computer-aided dispatch reports with narratives under the interagency or intra-agency advisory, consultative, or deliberative material exemption, NJSA 47:1A-1.1.
Is there any discussion? Hearing none, can I have a motion?
I move adoption.
Second?
John Alexi,
Yes.
Robin Brettavaki,
yes,
Christopher Brown,
yes,
Ronald Chang,
Yes.
Stephen Retadi,
Yes.
Scott Madlinger v. Borough of Seaside Heights Ocean, 2023-134.
The custodian's failure to timely respond resulted in a deemed denial of access, 47:1A-5G and 5I. However, the GRC declines to order disclosure because the custodian did so prior to or on the same date of the expiration of an extended time frame.
Is there any discussion? Hearing none, can I have a motion?
Move adoption.
Second?
John Alexi,
Yes.
Robin Brettavaki,
yes,
Christopher Brown,
yes,
Ronald Chang,
Yes.
Stephen Retadi,
Yes.
Next on the agenda are court decisions of GRC complaints on appeal. We have one. Mr. Rosato?
Yes, so this one was a bit of a doozy. So an extended background was needed to make sure it all made sense. So this one is Kubil versus Toms River District Number 1 Board of Fire Commissioners, Ocean County, 2024, NJ Super Unpub Lexus 2893, Active 2024. In July 2019, while appellant was a commissioner with appellee, the plaintiff requester submitted an OPRA request seeking, in relevant part, text messages and emails sent to and from appellant's personal email addresses allegedly used to conduct government business. The appellant did not provide those documents for review, and the plaintiff requester filed a denial of access complaint with the GRC in August of 2019. The council issued its first interim order in January 2021, ordering appellee to produce the responsive records. When asked by the custodian of the appellee's custodian to provide those records, appellant, who at this time was no longer commissioner, refused. In its March 2021 interim order, the council directly ordered appellant to produce the documents, but again, the appellant failed to comply. Next, in its May 2021 interim order, the council found appellant in contempt, end quote, and referred the matter to the Office of Administrative Law for a knowing and willful determination. The plaintiff requester also filed an order to show cause with the Law Division seeking enforcement of said order, which the trial court granted in February 2022. Well, the appellant will ultimately produce the relevant documents to appellee, and the council dismissed the matter in May 2023 in accordance with plaintiff requester's voluntary withdrawal. The appellant appealed the trial court and the GRC, arguing in part council's interim orders were null and void because he received no formal notice nor an opportunity to be heard. Council had no the council had no jurisdiction over 4 public employees and no authority to hold them in contempt. And finally, the underlying OPRA request was overbroad and unenforceable. Upon review, the appellate division initially found appellant was neither a complainant, custodian, nor intervener pursuant to NJAC 5:1L5-1.3's definition of party, and therefore held the appellant was not entitled to be noticed by the GRC of its hearings. The court further held the appellant did have an opportunity to be heard, finding that the appellant was first made aware of the OPRA request in July 2019, when he was still employed with the commission, and made aware of the denial of access complaint by February 2021. The court therefore held the appellant had sufficient time to file a motion to intervene prior to the GRC's March 2021 and May 2021 interim orders. Next, the court held the appellant was cognizant of his responsibility to produce government records while he was commissioner, and the responsibility remained even after his departure. Further, the court held the council's reference to contempt was not a determination of a civil penalty, but of the appellant's failure to comply with the council's interim order. Lastly, the court held there was no error in the council's January 2021 determination that the OPRA request was valid and not overly broad. Affirmed.
Thank you, Mr. Rosato. Next are complaints adjudicated in New Jersey Superior Court and New Jersey Supreme Court, and we have two. Again, Mr. Rosato.
This one is Thorpe versus Lieutenant Kenneth S. Kleinman, retired, CPM 2024 NJ Super Unpub Lexus 2738, active 2024. Appellant was denied access to an Oprah request seeking body-worn camera footage, dash camera, and mobile video recorder footage of any police officers in her vicinity while stopped for a traffic violation. At the trial judge's request, appellee determined there were response videos totaling 650 hours of footage. Appellee estimated it would take 740 hours to review the footage and proposed a special service charge of $21,460 to process the request. Although provided with an opportunity to narrow her request, appellant objected to the cost as excessive and being used by appellee to discourage access. The trial court therefore dismissed the matter with prejudice. On appeal, the appellate division affirmed the dismissal, finding appellant's arguments without merit. Next, and finally, we have Hill versus NJ Department of Corrections.
Excuse me just 1 second, just out of abundance of caution. I was involved as counsel in this case. I know this is just a report, but should I do anything, go on mute or otherwise?
I don't think there would necessarily need to be.
I would defer to our DAG, Mark.
I apologize.
I don't-
Could you repeat?
Ron,
So- I would say to the extent where the council's not taking action, this is
Right.
this is for information. So for Professor Chen, I guess as a matter of record, prior to joining the council, had been involved in this case long ago, and apparently took a very long time for it to reach a decision. And in the meantime, the appointment took place. So I would say DAG Gulbranson, because this is simply a report to the public on recent cases, that there's really nothing necessary on Professor Chen's part to do here.
I understand the need for, I appreciate an abundance of caution approach, but I agree with you, Frank. There's no real action being taken here. This is just reporting to the public.
Okay, thanks.
Thank you.
No problem. Hill versus New Jersey Department of Corrections, 2024 NJ Super Unpub Lexus 2794, active 2024. Appellant submitted an Oprah request seeking A, the legal access plan in effect at New Jersey State Prison, or NJSP, B, non-confidential policies, procedures, directives, or orders enacted by the appellee pursuant to specified executive orders of the governor, and C, similar records to COVID-19 related policies on social distancing applicable to NJSP inmates. In response to Part A, appellee provided a 4-page document entitled Legal Access Program, but denied Parts B and C as invalid. At the Law Division, the custodian certified that the Legal Access Plan and, quote, Legal Access Program, end quote, were the same record, but there was also an internal management procedure titled Inmate Legal Access that was confidential and not subject to disclosure. Regarding Part A, the trial court found the appellee violated Oprah by not indicating at the time of response the applicability of the confidentiality exemption and for failing to indicate the specific basis for denying the exact document requested by appellant. Regarding Parts B and C, the trial court found they were properly denied. The appellate division found that appellee properly responded to Part A, relying on the undisputed certification that the legal access program was the actual record sought by appellant. Thus, the court found that appellee's response was not a denial of access, warranting an explanation pursuant to NJSA 47:1A-5G. The court therefore reversed the trial court as to Part A, but affirmed as to Parts B and C.
All right, thank you, Mr. Rosato. Next is complaints adjudicated in U.S. District Court. We have none, so it's now time for public comment. The public comment period is limited to providing an opportunity for speakers to present suggestions, views, and comments relevant to the council's functions and responsibilities. In the interest of time, speakers shall be limited to 5 minutes per the GRC's bylaws. Speakers shall not be permitted to make oral or written testimony regarding pending or scheduled adjudications. Mr. Caruso?
Sure. So for our public attendees in attendance today, if you're interested in making a public comment at this time, you can unmute yourself by pressing *6. *6 will unmute you. If you'd like to make a public comment, I usually give a little bit of time for our attendees to determine whether or not they're interested. *6 will unmute you if you are interested in giving a public comment. Give about 15 or 20 seconds. *6, just to reiterate, allows you to make a public comment if you wish to do so. Give about another 10 seconds. *6 if we have any takers. Another 5 seconds. For any takers, *6. Again, one last call for public comments. And it looks like we have no takers for public comments this month.
All right. Well, welcome to the new staff. I hope everyone has safe holidays and see everyone next year. Do I have a motion for adjournment?
So moved?
Mute it again, Stephen.
Second.
Good way to end it.
Thank you,
John
John.
Alexi,
Yes.
Robin Brett-Tabaki,
Yes.
Christopher Brown,
Yes.
Ronald Chen,
Yes?
David Ritardo.
Yes.
All right. Well, happy holidays, everyone. I hope you enjoy it. It's a great time of year. We're going to get back to winter as regularly scheduled in a few days, but keep the raincoats handy until then and enjoy everything. Obviously, we'll be around if anything is needed, but we'll see you all in 2025, ladies and gentlemen. 2025. Crazy. So
Take care, everyone.
cheers. Have a good one.
Happy holidays, everybody.
Happy
Happy
holidays.
everybody.
Happy holidays.
Happy holidays.
Mhm.